Today's topic is actually IBC. I'm sure the participants who have joined in are obviously aware of the Insolvency and Bankruptcy Code, which was enacted in 2016. Today, my focus will just be on the various applications which are filed at the respective stages in a CIRP process, starting from how to initiate the CIRP, and then during the CIRP, how the applications are filed. I will just be taking a view on all the applications, not getting into the technical details of the rules and this applicable, because there are multiple rules uh, as in every application. Having said that, we all know that how the Insolvency and Bankruptcy Code came in, and it came in after the where initially in the Companies Act we had the provisions of inability to pay debts, and that's how that was removed and amended, and then came the advent of the Insolvency and Bankruptcy Code. Starting with the first application as such, one may look at Section 7, which is an application which is filed by a financial creditor. Now, a financial creditor does not has to issue mandatorily a notice under the IBC. The IBC code does not mandate an issuance of or default notice. However, as a matter of practice, most of the financial creditors do actually issue a notice, but it's not mandatory. Now, that application is filed along with certain documents. The most important factor, which I may say in a Section 7, is your debt and default. Now, just for clarity purpose, there came an amendment in during the 2020 where they said that the default amount has to be 1 CR. Earlier that it was below 1 CR. Now it is 1 CR, 1 crore. Now, for a financial debt, what is important is, and the most, as I said, is the debt and the default. And you also have to look at the ingredients of a time value of money. So that is something which is, these three are very crucial for filing of any application. As I said earlier, that there are certain documents on how you're going to prove the debt, whether it is in acknowledgement of debt, there is anything in writing, or there is an acknowledgement in the balance sheet. All that is a part of the Section 7 application. What also becomes relevant from a bank and from any financial creditor is the information utility, which was established, which is the NACL, which is established, which is basically it records your default. Now, again, there was a notification a few years back where it said that the record of default was necessary and you had to prove it by proving it by your information utility. However, the NCLT and the NCLAT takes the view that if there are documents which are proved besides the information utility records, that is also sufficient to prove the debt and default. Now, that takes care of a Section 7 application. Moving on to 8 and 9 is from an operational creditor's view. Operational creditor, just a quick, is a person who's providing any goods or services that will come under the ambit of an operational creditor. Unlike Section 7, to initiate a Section 9 application, which is from an operational creditor, the default amount obviously remains the same with 1 crore. However, here, mandatorily, what one has to serve is something known as a demand notice, which is under 8, which is in Form 3 or Form 4, depending on the facts of that case. Now, that is a mandatory stage. And after the issuance of notice, after you wait in for the deadline of 10 days, thereafter, after that, you have a right to file an application for under Section 9. What also becomes relevant in a Section 9 application is the existence. Debt and default obviously is there, but what is an add-on is in 9 is if there is any existence of a dispute. Now, dispute is explained in the very famous judgment of Kirusa, where they have actually said that the dispute which is existing obviously prior to issuance of a demand notice is something which the NCLT doesn't have to get into the facts. It only has to consider where there is a plausible dispute which may occur, which will then mean that parties should take recourse to civil courts and not use the mechanism of IBC under 9, because this is not a recovery tribunal. So that becomes little relevant before you file a Section 9, coupled with, as I said, again, your other underlying invoices, agreement, acknowledgement of debt, all that obviously also becomes relevant. Now, coming to a Section 10. Now, I explained from a financial creditor, I explained from an operational creditor. What if the corporate debtor itself, the company, believes that they have committed a default and would want to go by and use the IBC mechanism? That is where Section 10 comes in, where the company itself, which has committed a default, files an application for getting admitted in CIRP. What becomes relevant here is that the shareholders have to pass a resolution of 3/4 number to ensure that the company is in wanting to go for an application to initiate CIRP. What also is important is that of earlier, I think in initial time when the Section 10 was, the NCLT used to not ask for an affidavit asking that you are filing this application so as to evade some kind of proceedings. However, now as a matter of practice, some NCLTs do take this specific affidavit that you are not evading and you're not filing a Section 10 so as to avoid any kind of notices, whether issued by any statutory or including SARFAESI, etc. Having said that, Section 10 is a matter of right which the corporate debtor has, unless, as I said, it is proved with some malicious intention, which happens in very, very few cases. Otherwise, these are the mandatory provisions. What one has to look into, one is obviously your resolution, which is important. Even your books have to be to the date of filing of that application, which should be in place. And as I said, that there should also be a clear-cut default. In that sense, the company cannot service its debt, and that's why it wants to go under the CIRP. Then comes a very important provision of Section 12. Now, assuming now I explained for financial creditor, operational creditor, let's say now the company is in CIRP and the time frame within which CIRP has to be completed is 180 days, 180 extendable to 270, which then by amendment came to 330 days. Now, at every junction of 180 days completion, the IRP or the RP, as the case may be, the insolvency resolution professional or the resolution professional, will have to file an application for extension of time. Now, this becomes very crucial, which I will be subsequently talking, which was very relevant in the case of the Bhushan's judgment, which was passed on May 2nd by the Supreme Court. Because in that case, the extension of CIRP was not taken by the RP, and he continued to act as the resolution professional, which was actually contrary to the section, and which is actually even contrary to the law. And the RP must, or the IRP as the case may be, must seek approval of the NCLT to continue the CIRP. So at every given point of time, from 180 to 270 and from 270 to 330 days, he has to obviously go and take a specific approval. Even after 330 days, the law as held in SR's case by the Supreme Court is that 330 days is not mandatory, because if there is a situation that on the 29th day you receive a resolution plan, there are always chances for revival of the company. So at any given point of time, the RP should file an application and seek an exclusion or an extension of few days. Now, we've always seen in practicality, all these timelines actually go for 500, 600, 700 days also. And we have seen that in practical experience. But at every given point of time, what the NCLT and what the law demands is that you have to file an application. Then comes 12A, which again is somewhere relevant, is let's say in all these applications which are filed, somebody wishes to withdraw an application and the CIRP, It could be for the reason that the settlement has arisen between the applicant. It could be the financial creditor, or it could be the operational creditor. Now, the 12A application is usually filed by the applicant along with the IRP when he initially wants to withdraw the application. This can happen before the constitution of COC, after the constitution of COC, but not after the resolution plan which has been put by any resolution applicant. So there are stages where the application can be withdrawn. The application will require a 90% approval of the COC members, without which the application does not go through. And this one has to read with Regulation 30, because that is what is mandatory required to be followed. Going ahead in terms of once the CIRP takes place and the resolution professional has taken over the corporate debtor in any form, what usually the IRP and the resolution professional face is a non-cooperation. I'm sure everybody must have heard of this word of non-cooperation from the ex-directors and the ex-promoters of the company. Non-cooperation could be in multiple facets. That it could be of not providing of documents, not giving the required information which will enable the successful completion of the CIRP and even formation of the information memorandum which has to be prepared. So what the IRP and the RP, the code allows him to file an application and asking them to come ahead and cooperate with the IRP or the RP, as the case may be. And obviously, in default, there have been in practicality, we have seen that directors are actually summoned by the NCLT by even issuing warrants so as to make their presence before the NCLT. Thereafter, there is also a provision once in the CIRP of when, let's say, if the IRP or the RP needs to be changed. So let's say when I have to appoint an IRP, let's say under Section 7, where the financial creditor proposes or IRP, later they realize that the IRP, after 30 days, for whatever reason, they wanted to replace the IRP. There is a provision where the COC, in its wisdom, decides and files an application for replacement of the IRP. Thereafter, there is also a provision which talks about an authorized representative, which is again a very formal application which needs to be filed by the RP. Then an authorized representative is a person who, and these are very much relevant at the time of when there is, let's say, if it's a real estate company going into a CIRP, because there could be more than 500, 700,000 home buyers in a project. To have a representative on behalf of them who would be voting, because we cannot expect 1,000 home buyers to come in and vote, and it will not be possible to have a meeting. So there is an authorized representative. So there is an application which is filed by the RP saying that this is the person who's appointed as the authorized representative. 25, 26, I will come a little later. I will read that with the later sections of preferential and fraudulent transactions. 28 to some extent is also sometimes becomes relevant. Now, what is Section 28 of the IBC is basically where the resolution professional, along with the COC, take certain actions which are required for the running of the corporate data. Now, there are situations where there could be some discomfort between the COC and the RP, and some decisions are not taken. The RP or the IRP has an application which he can move before the NCLT and say that whether these decisions are required, and the NCLT can actually give some directions on that particular decision. Usually, these are very seldom used. Otherwise, the COC and the RP itself, given the powers they have, they always decided. But this is one of the applications which may sometimes be also become relevant. Then coming to 30 and 31, which I'm sure everybody will be aware, is of an approval of a resolution plan. This is like your final stages of, with every stage which is done, there is a memorandum which is prepared. Then there are resolution applicants who come in, and eventually a plan is approved with 66% of voting. Then the plan is put ahead under 30 and 31 before the NCLT by the RP. where basically the RP will obviously annex all his minutes, all his his information memorandum, his RFRP, everything, and will just disclose on the basis of the resolution plan that what exactly is the plan for the corporate debtor, which is going to revive the company. There are a whole lot of checklists which are required to be actually followed, and in practicality, a lot of NCLTs ask for a very typical format. I'm not getting into that, but that is the basics. Is you have to obviously give your Form G, your information memorandum, your RFRP, obviously your resolution plan, which has been approved, along with the voting results, which has actually held. To be in favor of that resolution applicant. Another important factor is the Form H, which is obviously required to be filed along with a compliance affidavit, which is under 29A. Now, 29A is an affidavit basically to say that the resolution applicant is not debarred under the provisions of 29A. In from A to H, there are certain factors. The RP has to make a compliance saying that yes, I have checked and the resolution applicant is not barred under these provisions. Thereafter, if the company obviously then, as per the provisions of IBC, there are situations where the company goes into liquidation. Now, what happens in a case where the resolution plan has not coming forward? What does the RP do? The RP has a mechanism to go and file for liquidation. What is the situation if the plan has actually been approved but not implemented? Then again, the RP or the monitoring committee, whoever is formed at that time, does also have a right to go in for liquidation. What also happens is that the time frame under the code and the COC realize that after 330 days also, we realize that nobody is coming forward for this company, and it's better not to waste further resources and let the company go into liquidation. At that time, the liquidator has the option, the RPN along with the COC, they will eventually go and file an application for liquidation. Obviously, then the liquidation process and everything starts in. Coming to the applications which are to be preferred during the CIRP and during the liquidation period by the resolution professional, obviously one more provision which comes is challenging a claim rejection of a liquidator, which is obviously under 42, where there is a claim which is filed during a liquidation, and if it is not accepted, there is also a mechanism where an application can be filed challenging the action or the order passed by the liquidator. Now coming to the applications, which I will term as the PUFE transactions, because that is another important applications which are filed during the CIRP and during the liquidation by the resolution profession. And if you'll recollect that I had mentioned about 25 and 26 sometime back, and I said that these are to be read with these applications. Why I call it PUFE, and it is quite easy because it just becomes easier to understand, is your preferential transaction, your undervalued, your fraudulent, and your extortionate transaction. Hence, it is PUFE, and it is very easy to actually. Now, what is this preferential transaction, and where is this application file? An application of a preferential transaction is only and only filed by the RP. It cannot be filed by anybody else. After the resolution profession and the IRP has taken over the company, he realized that there are certain transactions which has taken place, and in that sense has given a preference to a particular party. It could be related, non-related. For related party, we go up to 2 years from the insolvency date, and from a non-related, it is 1 year. Now, after that, the RP goes and files the application saying that this is obviously with the assistance of professionals. He may also make his own opinion, but I think most of the times I have always seen that people will obviously take in an opinion, because even the RP has to form an opinion and he has to take in an opinion from the auditor. So after that application, he files an appropriate application under 43, and then there are orders passed under 44. Now, there is also known as an undervalued transaction, again filed by the RP, where the resolution profession or the IRP would eventually come to know that there is let's say there is a property which was owned by the corporate debtor and which has been sold at a value. It could be any asset. I just give an example of a property. It could be any asset of the corporate debtor, which is sold at a value which is less than the even in the market value, so as to ensure that the creditors of the corporate debtor are not being able to get any fruits of that particular asset of the company. So that is a transaction where the applications are filed so as to reverse that transaction. There is also one provisions where only a creditor or any member of the corporate debtor can file an application under IBC. That is the only provision where, besides the RP, even a creditor can file an application for defrauding the creditors. I think it comes under 48 and 49 of the IBC, where any member or any creditor besides the RP believes that there are certain transactions which has taken place so as to defraud the creditors. Such an application can be preferred by them. Same checklist goes for them also, that they will coupled with a particular report. And then basis on that, the NCLT decides whether to reverse that particular transaction or to set it aside or to set it aside partly. Extortionate transaction, coming to the E part of the PUFE. Now, extortionate transaction is a transaction again filed by the RP, where after looking at the books, the RP or the IRP realizes that there has been certain financial debts which has come into the company, but the rates of the interest, and obviously these usually happens with the so-called related parties most of the times. Sometimes can also happen with but it is the terms of the agreement are so unconscious in that sense that no prudent company would ever want to get inside into that transaction. It's like taking a financial debt at 36 or 42% interest. I'm not talking about an NBFC or that, because an NBFC and that is usually their rate of interest. That is because it is regulated. But let's say if you take in and you are trying to make that, so that is where that extortionate word comes in, where it is actually where the conscious of the company that you could enter into such a transaction. So the RP has a right to even reverse that kind of transaction. Going forward, you obviously have, if there is any challenge of an order which is filed challenging a plan, or there is any material irregularity, there is provisions from the NCLT, it goes to the NCLAT. The one vital factor here to be considered is that any order has to be challenged within 30 and 15 days. On the 46th day, the NCLAT does not have the power to condone the delay. So that becomes very important and a very relevant aspect from a 61. Obviously, then 62 lies before the Supreme Court with a 45-day and a 15-day extension if the Supreme Court believes. Jumping to another provisions of 65. This was used just a few months back, or maybe a year back, to best of my recollection, where there was a application files for false prosecution of initiating a CIRP against a company. Maybe it could be on false documents. Now, this application can be filed by the so-called corporate debtor as existing before the director or anybody before the company goes into CIRP, to say that this application has actually been filed not with the intent to revive the company, but based on certain documents and information which are actually fraudulent in nature, and only trying to pressurize a solvent company to pay up its so-called debts. And that is why the application can be preferred under 65. Then comes the 66 and 67 application, which I'm sure again everybody would be knowing that it is a fraudulent application. Very important factor in a fraudulent application, there is no specific time frame or a time period or a look back period, as you may call it, within which an application should be filed, because that could go up to even 15 years back, Unlike in the preferential, if recollect that I mentioned that it was 2 years and 1 year. From a fraudulent aspect, it can go up to right up to 10, 15, 20, whatever years back, so as to show and have. And from an RP's perspective, there are two things which has to be proved. One is obviously a fraudulent and a wrongful trading. There are two different connotations. Fraudulently, with the aspect from, let's say, even a related party, could be under the ambit of a 66. I'm not talking about a third party. And a liability for a fraudulent and a wrongful trading by the directors and members. So there are two different things. And in these applications, a word of caution that most of the times the applications have to be drafted in a very, very particular manner so as to ensure that you are get your relief to the best possible. Otherwise, it is very easy to come out from the rigors of fraud. So it's got to be a very strongly in an application which is to be filed, especially under 66 and 67, because otherwise to match that ingredients, it becomes a little tough aspect. Then coming in terms of another important provision is also when, let's say, what happens in a situation when somebody has contravened the plan and is unable to execute the plan which he has submitted for whatever reasons, but has actually contravened the plan. So there is a provision under 74 where there is an application filed by the monitoring committee or the RP or the liquidator as a situation arises, where he will file an application to say that there is a contravention and the matter should be then referred to IBBI, and then IBBI then files an appropriate, if they find the case, they file an application or a complaint against the defaulter before the special criminal court. They do not get into the facts in this at this time. They only refer on a prima facie basis, and thereafter the complaint which is filed, the defaulter can then argue his case on merits in that application. Having said that, now with this is more from the CIRP and the liquidation. I will be just touching upon a little bit of even from the personal guarantors in terms of very basic application, because there are multiple applications where from an RP or a liquidator can be filed. But the basic applications which are obviously to initiate a personal guarantee, and it is here also in a situation the personal guarantor himself can file an application for getting himself admitted as an insolvent. Only and only a personal guarantor to a corporate debtor is what has been notified currently. The personal guarantors not related to the corporate debtor, those sections are yet to be enforced, for which there is a different authority, which is your DRT, your Debt Recovery Tribunal. As far as this is concerned, right now all the applications, because they are personal guarantors to the corporate debtor, all the applications lies before the same NCLT, where assuming the CIRP of the corporate debtor would have taken place under section 60. Another, before I jump, I also had one more. 65C is also a very application which is filed, because most of the times you see that the application, what is 65C? It's an application which says that anything to do during the CIRP or any question relating to do with the CIRP will be dealt by the NCLT under 65C. So 65C also is a very important provision where most of the applications one will see that are filed under this provisions read with your rule 11 of the NCLT. Rule 11 is basically being your wide powers which the NCLT has to decide. Coming back to the personal guarantors, as I was explaining, the application can be filed by the guarantor itself along with requisite fees in terms of the default. The creditor of the corporate debtor and to the guarantor can also file an application, but after serving a demand notice in Form B, which is a prerequisite to initiate the applications under the PG rules. Besides this, I would also want to touch upon and give a little background on what happens. Let's say the corporate debtor, which is not a company in that sense, but it is a financial service provider. What happens to that? One may ask that does that company also go into IBC? The answer to that is yes, because there have been specific rules which were framed, known as your financial service provider FSP rules in 2019, where there was specific set of rules governing these kind of companies, your financial service provider. So the mechanism almost remains the same. We just call them, the nomenclature changes from a resolution professional to an administrator. Otherwise, all the mechanism to be followed for submission of a plan, filing of applications, all that is exactly followed under the code. What is important is who initiates the action under these rules is your regulator, is your so-called appropriate regulator. Where just to give you a few instances, one was the Shrey Infrastructure Company, which had gone under this FSP. Everybody must have also heard about the DHFL, which was eventually taken over by Piramal. And obviously, one of being the latest one was the Reliance Capital. All these cases where, because the RBI being the appropriate regulator, unlike how in a Section 7, a financial creditor, operational creditor, the applicant files an application, here it is the appropriate regulator, which is the Reserve Bank of India, becomes your applicant and files the applications. Process and procedure, as I explained, it all remains the same, because that's something which is deals in exactly under the IBC. As I said, only the nomenclature in that sense, it changes, and it is termed as an administrator. Otherwise, all the other mechanism from submission of plan, filing of applications, all remain the same. I think this was to give you a very broad on the applications which are filed, as I said, from PG and from a personal guarantor and from bankruptcy. There are multiple other applications which are being filed, because there is a repayment plan which has to be submitted. What the resolution professional does on a quarterly basis is also supposed to file his progress reports. These are all some of the applications which are obviously filed. And obviously, the same way from a personal guarantor as compared to the corporate debtor, there are also applications which, in case if the person guarantor has, in that sense, siphoned off or has done something in the previous, prior to his commencement, his PG commencement date, that can also be brought in light before the NCLT. Certain other applications for his travel purpose, etc., all that are taken care on the by the RP under the PG rules. Having said this, I would now want to speak on which was the second part of the today's discussion on today's topic, was the Bhushan's judgment, where the Supreme Court on May 2nd, and it actually deals with why this becomes relevant is because there are exact, I mean, on a personal view, I feel that the Supreme Court has come down really heavily on the way the IBC was functioning, and how certain regulations and the law have, in that sense, really taken a backseat, which is not actually the mandate of the court. So I think it just came like an eye opener. The judgment where JSW had taken over the Bhushan, which I'm sure everybody was must have read in the news, and even as of yesterday, where the Supreme Court has stayed the liquidation. So I think it was really like an eye opener, which the Supreme Court came down heavily on a lot of factors. Bit harsh, because if one has to look at from an industry perspective, Supreme Court could have possibly just said that this was one of her case, and may have just left it there instead of opening a Pandora's box and putting it under liquidation for a plan which is already implemented 4 to 5 years back. Having said that, what was this case about? It was so if one, just to give a recap, RBI in 2017 had taken out a notification where there were these top 10, 12 companies having huge debts of more than 40,000, 50,000, 60,000 crores, where they said that these companies have really defaulted in their loans and they are NPAs standing on the banks for many years now. So to reduce, and because the IBC was introduced in 2016, they said that these companies shall be referred to the NCLT mechanism and the CIRP process. That's why in one of those lists came in a Bhushan power where the company was admitted into CIRP. Thereafter, there were various litigations and everything filed. There was also a situation where post admission of the CIRP, the Enforcement Directorate had also attached certain properties of the promoters and the company. I will be discussing that a little later as I discuss in the facts of this judgment. After that, it so happened that there were, as I mentioned, that there were multiple litigations which were filed. But what the Supreme Court came down heavily on these three, four, five factors, which became really relevant for one to think. One is, if one remembers that I had mentioned some time back, the IRP or the resolution professional has to seek extension of the CIRP process. Now, in this very case, the resolution professional failed to take any action and file any application for extension or exclusion of the CIRP. The Supreme Court came down heavily to say that you, as a resolution professional, as an IRP, knew that the days as mandated under the code had lapsed. So it was the duty of the IRP and the RP to come forward and file an application for extension or exclusion as the case may be. So that was something which was really the court came down heavily on the RP for that. The second was in terms of the compliance. So just to give a 2 minute background, the IBC and the regulations in the code are all process and regulation driven. Everything has to be done in a specific manner. Now, if there is some material irregularity which is found within the process, that's where your exact challenge comes before, and most of the appeals are filed where the process is run not in a very transparent manner. Now, even in this case, in the Bhushan's case, is that the 29A affidavit was not taken, which was a compliance, as I explained when I was talking about 29 and 30, when you file a submission of plan. These are very mandatory provisions which one has to take care of filing this affidavit. Now, the compliance affidavit, for whatever was not filed, or it was not filed in the particular form, so as to evade the so-called connection between I'm not getting into the more factual detail, because that has a little more debatable, and 29A itself is a very vast topic, so would not get into that. The third aspect, which also came down and which I also personally believe is something from a COC's commercial wisdom. Now, we must have read a lot about COC's commercial wisdom is paramount. Nobody will interfere unless there is absolutely a grave material irregularity. However, I think it is in this case that the COC members actually did not, or rather, I would say, at one given point of time, ensured that the applications or the plan which had come ahead, they did not discuss the commercial viability and feasibility. And after having discussed and after having found certain irregularity, despite that, on the next day, still go ahead and approve the resolution plan for whatever worth. And even the changes allowed to the resolution plan once approved, which is also not mandated under the code. So the court actually looked at the entire conduct of the CRP and said that if the COC, who's actually called the protagonist of the CRP, because they are driving the force after the resolution profession. So it becomes of utmost importance that if they fault in their duty, they are actually hampering the stakeholders, the other stakeholders who are involved in the entire process. So I think the COC wisdom was actually questioned, and I think after really, I just remember one of the judgments where in I think the Shiva Industries, where the Supreme Court, where there were certain rules which were framed for COC's wisdom, that their commercial wisdom is not always wise. But having said that, I think it is time that the legislature will look at certain amendments to this COC's wisdom. I think the process itself in Bhushan's case was that, and even the banks in that sense, as I said, sitting on that CRP, and were not actually being able to act on their commercial wisdom, because viability and feasibility is something which is only the domain of the COC members. And if you fail in that primary duty, the entire process goes. Another important factor which was also considered by the court was the non-filing of applications, as I mentioned under PUFE some time back, the preferential undervalued. The court actually said that you knew that there were certain ED proceedings which were ongoing. Must be knowing that there is, because the debt was around 45,000 crores, which eventually JSW took over at some 19,000 odd crore 4 to 5 years back. So they said non-filing of an application is again breach of your duty, which is required under the code, and you failed to do that. Another factor was, and I think this is really going to have a lot of ramifications for the successful resolution applicants once they take over the company, was the proceedings which were the attachment of enforcement directorate of the assets of the corporate debtor post the commencement of CIRP. Now, in this case, it so happened that after everything happened, the CIRP had commenced, and then the IRP and the RP took over, started his business, and doing from information memorandum issuance of RFRP. The enforcement directorate, basis on the complaint, goes and attaches the properties of the corporate debtor and of the promoters. Now, this was the time, because the timing in this matter was very crucial, because this was a time of 2017 to 18, and immediately thereafter, I think few months later, there was an amendment which took place in the IBC. The amendment was a 32A, where basically the amendment had spoken about the fact that any liability for past offences of the corporate debtor should not be fastened on the corporate debtor. You can very well continue the proceedings against the promoters and the directors of the company, but not against the company's assets per se. Now, very surprisingly, that the Supreme Court actually went ahead and mentioned that, and actually held that the proceedings before the PMLA and the proceedings before the NCLT will not have jurisdiction to get into the aspect of the attachment given by PMLA under the public law. For the simple factor, because that law and this law is a complete different realm of law. That is because it has the aspect of money laundering, and though IBC being the subsequent code. However, I think now, because of the review which is going to be filed by JSW, I'm assuming all these points will come across. But on a personal note, I think this is going to have a little ramification, because where does the successful resolution applicant eventually go? Does he go before the PMLA court and then get his application and get his attachment, detach his properties in that sense? Or does he still maintain, because there are still judgments holding the fort as of today also, which says that no, NCLT is the correct forum. In fact, our own Bombay High Court has held in one of the matters that the NCLT is the right forum to go and seek immunity under 32A once the plan is approved, because the theory is of a clean slate theory. So what happens in that situation? So I think these are this judgment, I think by far, at least in my personal experience from 2016, this judgment has really shook the entire IBC process and mechanism. I mean, there have been earlier judgments of Innoventive, SR, and everything came, but everything came with a more developing law. But this actually just changed the entire mechanism under IBC. But as I said, as of yesterday, the Supreme Court has put a stay on the liquidation, because eventually the Supreme Court said that nothing doing, I'm going to reverse this. And as I explained under 33, if the plan is for material irregularity set aside, the company then has to be gone into liquidation. That's the mandate of the court. And that's exactly what the Supreme Court did. However, because having these ramifications all across, because the banks have already been paid money, there would be a situation that the banks have to return that money back. So I think it was going to create a lot of ramifications. So we'll have to only now wait and see what does the review petition have for us. And I'm sure that there will be a lot of clarity which will be put in by the Supreme Court, if not by the legislature. So I think this had, as I said, this was one of the cases where in so many years, which actually came out very heavily down on resolution professionals, the COC's conduct, on every aspect, and how the IBC was actually running. So we'll have to only wait and watch what does the Supreme Court deal in their review. So that's about giving you a little brief on the Bhushan's judgment. I think that's it from my end. Would happy to take any questions.
Diksha, there's a question.
Yeah.
Any material that you can suggest where we can find the pro forma for these applications?
So, just if one just reads the IBC code along with the regulations, all the forms and formats are actually mentioned in that, along with the NCLT rules. So, I would suggest anybody read the code with the regulations and the NCLT rules. That will give you the entire format and the forms.
Okay. The next question, what are the essential elements of a demand notice?
So essential elements from a demand notice is obviously you need to prove from on what basis the underlying document. So when I say document, it could be an agreement, it could be invoices. That becomes absolute relevant. Your limitation again becomes very important. It's not that you have invoices of 2009 and you don't have an acknowledgement of debt as of today. That becomes important, and annexing the right uh, documents and invoices along with the claim amount becomes very crucial from a demand notice, because a demand notice is your precursor to filing of a section 9. So that has to be very carefully put in, and whether it's any correspondence, whether it's any acknowledgement of debt, whether it's your invoices, whether it's even acknowledgement in a balance sheet, uh, everything should accompany in the form of that demand notice.
Okay. The next question is, what is the distinction between the role of a lawyer and the role of a resolution professional?
So, an IRP or a resolution professional actually is the one who's running. I mean, I always call them as like a CEO or an MD of a company once the company goes into an IBC or on a CIRP. So his role is more of running the company like a professional. Obviously, from a lawyer, and why is he obviously different is because he's not here to perform all the functions. He does not do audit. He doesn't do forensic. He's not going to come and file applications. That's where he takes the assistance of lawyer, because he doesn't have that expertise to go. His role is as a professional to run the company as if it's a going concern even during CIR. And he then takes external help like lawyers, auditors, chartered accountants to assist them in driving this CIRP and getting it through its logical end.
Okay. Can you briefly explain the clean slate doctrine?
So the clean slate doctrine is a doctrine which was slated by Justice retired Justice Nariman in the SR case. Is that when a company, if I have taken a company which is undergoing CIRP, and when all the claims have been satisfied under a resolution plan, when I buy out the company, the code mandates and actually favors the resolution applicant to get the company on an absolute a basis where he doesn't have to deal with any past liabilities. Every liability will then crystallize at the time of the insolvency commencement date. Let's say if 100 rupees is crystallized and I have predicted 20 or 30 rupees to be paid to that company. From a resolution applicant's point of view, I would not be suddenly getting a claim which is after I take over the company for an additional 50 rupees, whereas I've already settled the account for 100 to a 20 rupees. So the clean slate theory is a very simple theory that all claims as per the commencement date and as per the resolution plan all get crystallized. Thereafter, there should not be any liability whatsoever on the resolution applicant taking over the company. That's why the word clean slate, that I take it absolutely clean of all obligations. I have cleared everything. I start on a fresh basis. Whether it's your income tax dues, whether it's your past dues, your bank's dues, your operational creditor, workmen, etc., all the dues, everything gets crystallized and I start afresh.
What would be further proceedings in case of GSW?
So further proceedings, as I mentioned, that the review is going to be filed by GSW, which has already been confirmed yesterday before the Supreme Court. So one will have to be seeing that what will lie in that review by GSW. So a review is what they are going to look at.
Okay. Can you explain the conditions under section 29 no under 29 amperes that are debarred as you have mentioned?
So the criteria, as I said, 29A is a very vast and it really requires a separate session for it. But just to give a very brief on 29A is the ineligibility criteria which any RP has to follow and has to see whether it could be one of a willful defaulter, whether he is obviously in that sense connected to a particular company where there is a default which has taken place. Any of these A to G, there are A to H, in fact, there are multiple, as I said, where debars that particular resolution applicant who cannot take over the company. It could be also a situation where somebody who has contravened a particular plan. There could be a situation where he's anyway connected to a particular company or a person where he himself is a defaulter and his company through he himself has some kind of a interest in that company that will also debar him under 29. So there are conditions laid down under 29 and it's quite vast because as I said 29A, I mean, can go on for the next 2 hours. It's a separate topic in itself because it's quite technical and has to be seen with an absolute lens from an RP. That's why in Bhushan's case, this became very relevant. Now, I'm not getting into the fact that whether that was right or wrong because the Supreme Court did not get into it, but that is a very, very thin line of 29 and has to be seen. And that is why most of the RPs do their diligence, but they also take third-party external reports so as to be double sure that there is no default or there is no go by to that provisions of 29.
Could you please reiterate under what circumstances a compliance affidavit is mandatory?
So a compliance affidavit, just to give you, if you want if you're looking at the grounds, is one is that if the applicant who's not eligible to be a resolution applicant is one who's an undischarged insolvent, he's a willful defaulter declared by the RBI at the time of submission of a plan. Let's say there is a person or a company who's in control of that company where that company is being declared as an NPA and at least 1 year has not lapsed. And this specifically, if I may pause here, had happened a situation in SR's case where the resolution applicant, Arcelor, had to clear off dues of a third company because his brother was involved or rather had a indirect connect to that company. And because that company was declared NPA, he could not have bid for SR. So that is where he had to clear that dues so as to become eligible under 29A. Obviously, a related party, and obviously if you are convicted of any offense for an imprisonment, that is another one where your compliance will be required. If you're disqualified under the provisions of Companies Act, where that is also something which is you are compliance affidavit will be required. You are not prohibited by the SEBI in dealing and accessing the securities market. Obviously, if you have been a promoter or a management of a corporate debtor, where you yourself have been involved in a preferential or the PUFE transaction, and let's say that you yourself have committed any fraud, that will also mean a compliance. If you have expressed any, if you have favored any guarantee, and if you any guarantee which remains unpaid for a particular corporate debtor, that will also something where a compliance will be required. Any connected persons to all this, and there's a huge definition of related party under the IBC, and it is different what it happens under the Companies Act. All these persons connected do also automatically get barred. But again, as I said, there are distinguishing factors where one can distinguish, and I can just ask everybody to possibly read up the SR judgment on this aspect of 29AG, because I think it's very beautifully explained um, by Justice Nariman on 29A. So that are the factors what, and that is why the compliance is required under 29.
Okay. So Dikshit, we are done with the queries. Can we conclude?
Yes.
Okay, so Dikshit, on behalf of the PLEA team and the participants, I thank you for such an illuminating session. Thank you so much for your time and efforts.
Thank
It
you.
was a great learning experience. Thank you.
Thank you, Anand. Thank you.